Welcome back, viewers, to the PI Show. We're talking about the Supreme Court decision of Justice Kyrou, Tony, who is the first Greek judge to be appointed to the Supreme Court, Tony. Greek-born.
You've got aspirations, John.
Maybe one day, Tony. But in any event, of Pasqualotto in the Supreme Court, Tony. Now,
and for your information, John, I went to university with him. Now, before the break, we kept them in suspense. What was the key question that the jury and the court had to determine on this issue of whether there's negligence on the part of the employer?
Mr Brazenor advised Mr Pasqualotto to simply not do heavy work.
Stay away from anything heavy, because you're very, very susceptible to further injury.
That's right.
To the same body part, which is the lower back.
That's exactly right.
Now,
so he knew he had to be careful.
Now, this matter went before a jury of 6 in the County Court of Victoria, Tony.
Yes.
There was a finding in the plaintiff's favour, the worker, the injured worker, $400,000 for pain and suffering, Tony.
That's a lot of money.
Pretty.
His back's pretty bad. A very young fellow,
He's
too.
young, and $440,000 for economic loss.
For loss of income. Yeah,
that's a total of over $800,000.
But then, sadly, he lost 70%, didn't he?
That's right, because it was found that there was contributory negligence.
Well, he shouldn't have been doing the work in the first place.
So, Tony, contributory negligence, what's that?
Contributory negligence, in short, is the contribution by the worker to his own injuries. And that's in simple language. But can I say this? When this went to the Court of Appeal found that there was no negligence on the part of the employer because they couldn't work out whether...
Well, the interesting thing was, one of the questions that the court had to decide was it the mother had gone, or if the mother had gone to the appointment of Dr Brazenor with the employee, and whether the mother ought to have known that, you know, the son needed to have been careful. That's right. So,
but the mother, viewers, was also the employer. That's why we got the reference to the mother.
That's right. It was interesting.
So, Tony, the jury, and this was upheld by the Supreme Court, found that there was no negligence on the part of the employer. However, there was a breach of statutory regulations.
That's exactly right.
On the part of the employer, and therefore the plaintiff succeeded in the application.
I think one of the most important things to come out of this case is that a breach of the regulations won't require a finding of negligence or the possession of any particular knowledge by an employer, of any susceptibility by the employee. So I think these days, lawyers in particular will be advising their clients to pursue a lot of claims, not only common law negligence, but breach of regulations. And how many regulations are there, John?
Oh, there's a multitude,
Many.
Tony. Multitude. The handling regulations, the goods regulations, there's a multitude.
And there's regulations to do with electricity, lifting, climbing, scaffolding. It doesn't stop. There's a multitude of regulations. Look, let's move on from this case and get on to the one of Sharif, which you're very familiar with, John. Can you give us the facts of Linton Sharif?
Tony, Linton Sharif, it was initially a Supreme Court jury verdict in the plaintiff worker's favour of over $1 million. The jury was discharged by the judge, and it was judge alone, and a verdict of over $1 million, 1.1 approximately, which was then reduced again by 20% for contributory negligence. So the plaintiff received approximately $800,000 for the injuries he sustained in the course of his employment with Elizac, who was owned and operated by Mr Morgan, Gary Morgan. Now, the defence was
Can
that...
I stop you there for a minute?
Yes.
Nadia, tell us a bit more about the facts of how you got injured.
Actually, it's a very interesting case, and I think a few viewers would be interested in hearing about this case because it involves a contractor, or a subcontractor, more rather, and he was working in a building just in Collins Street, so it almost feels too close to home because this can happen on a daily basis. He was, the issue was whether he was a contractor or whether he was an employee, and therefore whether he had rights under the Workers' Compensation
Well, he fell
Scheme.
down a lift well.
That's right. He fell down a lift well in the building. when asked to fix the lift because the lift was not working.
But significantly, he had one of his arms.
Yes, he'd had a prior work injury where he'd injured his wrist or his forearm, so he knew that he had an injury.
So he was working effectively with one arm.
That's right. So he got into the lift well and essentially used a ladder and fell or slipped, and there's debate about what actually happened,
yes,
and injured himself.
In fact, can I just say this? I'm convinced that no one really knows what happened. Because bottom line, reading this decision, there's no certainty as to how he got injured, John.
Tony,
apart from the fact that he's fallen in a lift well.
Tony, I was there at the View before a jury and the judge during the court case where Mr. Sheriff was showing exactly what happened, as in the ladder was placed in this dark stairwell. We all looked into this stairwell, which was totally dark, and he says he was on the ladder inside a dark stairwell, and basically the lift came down upon him and basically hit him, and he's fallen from the ladder.
But John, the judge that heard the case in the first instance didn't accept everything he said.
Exactly.
He said that, as far as I'm concerned, I don't accept his evidence, not because I don't believe him. I don't think he even knows 100% what happened.
He did accept that he sustained a nasty injury, as in almost an amputated foot.
Yes.
However, Tony, this has gone to the Court of Appeal.
That's right.
One of the main defences of the appeal is that Mr. Sheriff was not a worker.
Well, the long-ranging thing that came out of this case was the court turned their mind to subcontractors and employees. He won his case in the first instance because he was a deemed worker at law.
Exactly.
That's
But the Court of Appeal then said he's not a worker under the legislation, and the main reason for that, Nadia?
Basically because they looked at the relationship between who was giving instructions and who was receiving the instructions.
Yes. And importantly, John, when he was getting paid, what happened there?
He was getting paid $450 gross per day by Elizak, and basically he was able to do really... the control was not as tight as tight as we would like under a worker.
In terms of payments, wages and that, the employer never... Mr. Morgan didn't pay him his tax.
No, he took out his own tax.
No. Didn't pay him his work cover.
Mr. Sheriff actually employed other employees,
and that was very significant in the eyes of a court,
via his own company.
Essentially, everything was looked at.
Now, Tony, this matter is under appeal to the High Court of Australia,
which is interesting.
I understand Robin Gordon QC has drawn the papers and lodged those with the High Court of Australia, requesting leave to appeal this.
Well, in view of what John's just told us, we'll keep you posted about what happens in the future. But importantly, the message I want to send to viewers is there seems to be a lot more subcontractors out there that aren't insured. Don't take the risk.
That's right.
More often than not, you're not going to be a worker these days. You're not going to be deemed to be a worker. So if you haven't got insurance, you might not be covered. You might be caught between the devil and the deep blue sea. So take out some insurance. It's relatively cheap. OK, viewers, we've got to go to a sponsors break. So stay tuned. We'll be back with the mailbag. Thank you.